Hello, I'm attorney Vince Davis. Navigating family law in California can be a complex and emotional journey. Today, we're going to break down the key elements of child custody and visitation to help you protect your family's future. First, let's understand legal custody. This isn't about where the child lives, but who makes the big decisions. It covers things like where your child goes to school, their health care, and even their religious upbringing. Physical custody, on the other hand, determines where the child actually resides on a day-to-day basis. In California, this can be joint, where time is shared, or sole, where the child lives primarily with one parent. Keep in mind, joint physical custody doesn't always mean a perfect 50-50 split. It means frequent and continuing contact. When a judge makes these decisions, they follow one primary rule: the best interests of the child. Under California Family Code Section 3011, the court looks at the child's health, safety, and overall welfare. They also consider the emotional ties between each parent and the child, and the parent's ability to care for them. If a child is 14 or older, California law actually requires the court to consider their input on where they'd like to live. Before you ever see a judge, California requires you to attend mandatory mediation through Family Court Services. The goal is to help parents reach an agreement on a parenting plan without the need for a contested court hearing. Safety is the court's top priority. If there's a history of domestic violence, it significantly impacts custody. Family Code Section 3044 creates a presumption that awarding custody to a parent who committed domestic violence is not in the child's best interest. New legislation like Peaky's Law has further increased oversight to ensure children are protected from unsafe environments. What happens if one parent wants to move? These are known as move-away cases in California law. A parent with sole physical custody generally has a presumptive right to move, unless it's proven the move would harm the child. You must provide at least 45 days written notice before a planned move to give the other parent time to object. Custody orders are rarely final. As your life changes, your orders may need to change as well. To modify a permanent order, you must show a substantial change in circumstances that makes the current order no longer suitable. Beyond custody, child support is a critical part of family law. California uses a statewide uniform guideline to calculate support payments. Recent changes in 2024, like Senate Bill 343, have updated these formulas to better reflect modern economic realities. Spousal support, or alimony, is another complex area. It's designed to help a lower-earning spouse maintain their standard of living. In long-term marriages of 10 years or more, the court has broad discretion in determining the duration and amount of support. California is a community property state. This means most assets and debts acquired during the marriage are split 50-50. From your home to your retirement accounts, everything is on the table. It's vital to have a clear understanding of what constitutes community versus separate property. Complications often arise when separate and community assets are mixed. This is where specialized legal formulas like Moore-Marsden come into play. Ensuring an equitable division requires a meticulous review of your financial history to protect your long-term interests. When we work together, we aren't just looking at the present. We're developing a long-term strategy for your financial and emotional well-being. Our goal is to create a stable foundation so you and your children can move forward with confidence and peace of mind. The legal process can be daunting, but having a roadmap makes it manageable. We guide you through every step, from filing to final judgment. Whether it's a summary dissolution for short marriages or a complex litigation case, we provide the expert counsel you need. With nearly 40 years of experience in California family law, I've seen it all. I know how to navigate the system to get you the best possible result. My experience means I can anticipate challenges before they arise, saving you time, stress, and unnecessary legal fees. Every family is unique, and the laws are designed to be flexible to your specific needs, but you shouldn't go through this alone. Having an experienced attorney by your side can make all the difference in achieving the best outcome for your children. If you have questions about child custody or any family law matter in California, please reach out to us. Call us today at 888-888-6582. Let's work together to protect what matters most.